assault with a dangerous or deadly weapon, 901 falls under 706 or 90103.
Yes, it does. Under 901.03b, when it says, for the purpose of this section, violent crime includes any criminal act that results in death or physical injury or any criminal use of a deadly weapon or dangerous instrument. And so that would necessarily include aggravated assault, reasonable apprehension with a gun.
Okay, what was he charged with? Though, does aggravated assault with a deadly weapon, I think that's the one that, I think that's what we were looking at. Right. Does that fall under 90103?
That one does as well. So all aggravated assaults that are he's charged with would fall under that. And of course, first degree murder, second degree murder, manslaughter would fall under 706. What the state is asking for is just the additional language for reasonable apprehension by use of a gun under 901.03.
So, all right, Mr. Davidson, your response?
Your Honor, I would actually suggest that we don't need that second bracket paragraph because that talks about a situation where display is not justified in situations where a weapon is used during the commission of a crime. And the juror's question, as I understand it, isn't about the use or the discharge of the weapon, but the legality or lawfulness of the manner in which it was possessed or displayed or brandished. So I think if we start throwing that extra explanation in, that we run the risk of confusing the jury, and we give them more information than is needed. If the court is inclined to include that sentence about the situations in which the use of a firearm would remove it from the purview of defensive display instruction, I would suggest that we enumerate first degree murder, second degree murder, manslaughter, and this aggravated assault, serious physical injury, and aggravated assault with a deadly weapon to aggravated assault that the defendant is charged with. The defendant is not charged with reasonable apprehension. Aggravated assault, frankly, the defensive display of firearm justification instruction itself, Your Honor, viewed in totality, speaks directly to that. I mean, in other words, as the state's been arguing, and I don't think necessarily incorrectly, that this justification instruction is probably more typically applied, although not exclusively, in a situation where we're dealing with that apprehension charge. And so I think it's already inherently there. When we're talking about defensive display and possible criminal liability that can arise from merely displaying a gun, that's what we're talking about. It is an apprehension, aggravated assault. I think if we start giving the jurors elements of crimes and crimes that the defendant has not been charged with for purposes of determining, the legality or lawfulness of conduct that has not been in and of itself charged as a crime, we're really going to confuse this jury. And then we run into questions of, well, how do we determine if the defendant committed this apprehension, aggravated assault? Is it still the state's burden? Is it the defense burden? What's the burden of proof on that? What if, what they also run the risk that they could use that type of aggravated assault and incorporate it into other instructions that refer to aggravated assault. I think because the defendant's already charged with serious physical injury and a deadly weapon, aggravated assault, and they've been given very clear and comprehensive instructions on how they're supposed to make that determination, I think it's perfectly sufficient to just refer to those as disqualifiers without muddying the water and introducing this brand new crime that they haven't heard of before in a context that's going to make it very confusing for them to determine how to apply. regarding pointing a gun at an unarmed person. They're talking about an offensive display. Is it a threat? Is it an assault? Is it a crime? So they're asking for the definition that would be applicable. And certainly, pointing a gun at somebody with the intent to inflict reasonable apprehension of physical harm would be included in that. So if we're gonna include construction, which the state suggests we don't, but if we are, when we have to also define reasonable apprehension as well as part of those enumerated offenses, and that's certainly encapsulated in that bracket language. He wasn't justified in displaying the gun vis-a-vis meeting the requirements of the justification instruction, then he wasn't justified as to an apprehension aggravated assault. That's my point, is that this justification instruction talks about or is tailored to situations where finding where a person is justified, for example, in placing someone in apprehension. So it's of no moment or consequence whether or not Mr. Jones had the intent to place people in apprehension. The question is whether that intent was justified under the circumstances.
All right, I'm not going to give that offense. He's not been charged with it. And I think the jury needs to be directed to the actual charges that Mr. Jones has been charged with. I'm going to give the defensive display of firearm instructions, omitting the last paragraph regarding the burden of proof that the state has, and I'm also going to not give the reasonable apprehension aggravated assault, this aggravated assault reasonable apprehension as one of the crimes. And so I'll go ahead as to the rest of it. Questions 1, 2, and 4, they'll be instructed you are to rely on the instructions, your wisdom, common sense, and experience to answer this question. I just want to make sure, Carrie, I'm going to send this to you. Would you PDF that down to the attorneys so that they can read that?
All right, so Carrie is going to send that out. I just sent it to her. She'll send it out to counsel so that you can see. I'm going to wait until you have a chance to review it to make sure that it's at least grammatically correct.
All right, Judge, I just want to put on the record our objection that what the judge is proposing to give back to the jury does not actually answer the question, which is pointing a gun at a person, is it a crime? If we don't give that reasonable apprehension instruction, they're not given the correct answers. Thank you.
Your objection's noted. Let me know when you've received it. I don't want you guys to, I don't want counsel to hang up yet.
I'm still here, Judge.
Okay.
It just arrived, Judge, so let's take a look at it.
All righty.
See a typo, Judge, already under number 3.
Okay.
The protection, just at the bottom, attempted use of unlawful physical force. Oh, no, never mind. I read that incorrectly.
Okay.
Sorry, let me keep reading. The only correction besides including the reasonable apprehension element would be under number 3, at least the way it was sent to me. I just want to make sure. I don't think, under number 3, I think that second sentence is separate. I don't think that's one of the, you know what I'm saying? The defendant was not
Okay.
required to defensively. I think that's just a separate statement.
I think you may be right. When I read that, it just didn't make sense in the context of number 3.
Right.
Your Honor, Joshua Davidson on behalf of the defendant. 1 and 2 look appropriate. For number 3, the first paragraph, I believe, should state the defendant is justified in defensively displaying a firearm if a reasonable person would have believed that physical force was immediately necessary to protect himself against the use or attempted use of unlawful physical force, and then remove the comma after unlawful physical force and have it read unlawful physical force or deadly physical force.
Okay, so you're under the first paragraph on the third question, the first full paragraph. Is that what you're referring to?
Yes, Judge.
And
I think we need an or between use and attempted use. And I think the comma after the last unlawful physical force should be removed.
So it would read, the defendant is justified in defensively displaying a firearm if a reasonable person would have believed that physical force was immediately necessary to protect himself against the use, comma, or attempted use of unlawful physical force, no comma, or deadly physical force.
Yes, except for I would omit the comma after use. I would just have use or attempted use without a comma in between.
So you're just against the use or attempted use of unlawful physical force or deadly physical force, no commas.
Correct, Judge. And I had just one other thing I was going to nitpick at.
Go ahead, pick away.
Okay. If you go to the second item of what that's, excuse me, let me back up. If you go down 2 paragraphs, the defendant intentionally provoked another person to use, comma, or attempt to use unlawful physical force. I think that comma, that first comma after the word use, is unneeded.
Well, I don't want to get too crazy, but I actually think the commas are necessary. I think grammatically that's where they're supposed to go.
I've never been accused of being a guru on grammar.
Well, neither have I, but you know. Okay. Anything else?
And, Judge, I agree with the prosecution that that final sentence in, again, talking about number 3 is
Right.
appropriate to be a standalone item.
I put it there as standalone.
The only other thing I'd ask, and perhaps it's more of an inquiry, I'm looking at the definitions of serious offenses. I don't see where negligent homicide is mentioned. Unless there's some other legal or statutory reason for that to be included among the enumerated offenses, I'd ask that it only go down to manslaughter.
Okay. Again, I was kind of doing this on the fly. I think I just went ahead and put that in there. All right, I've taken negligent homicide out.
So, Judge, as I'm looking at this, I see another problem, and it's bigger than just some grammatical issues, because the question the jury is asking is what does one say regarding pointing a gun at an unarmed person? Is it a threat? Is it an assault? Is it a crime? We're answering it with an instruction about defensive display, which talks about the use of physical force, that it's okay to display a weapon in response to physical force alone. That changes the whole dynamic, which is if he's offensively displaying this gun, then, and it's only response to physical force, that's the wrong definition we're giving them, because deadly physical force can only be met with deadly physical force. You see what I'm saying? So this, in the way it's been given in the context of the question, it really changes the whole dynamic of when it's okay to use a gun in this situation. Again, they're asking, what is it a crime to point a gun at somebody, not defensively display, and we're just assuming that that's what they're referring to. But what the words actually in that question mean, is it a crime to point a gun? And now we're saying it's okay to, answering it, it's okay against physical force alone, and that's a problem in the state's mind, and I think it's just going to confuse the issues even further.
I think defensive display of a firearm is a legal term, and it's unrealistic to expect a jury to use that with I don't mean that to be disparaging of that, but I think that's a rather lawyerly term to expect a jury to use in a question and a basis upon which to withhold answering because it wasn't asked in that context or using that terminology. Moreover, I think if you go down to the defensive display of a firearm definition, which enumerates the 3 situations that includes, it certainly encompasses what they're asking about. I think what I would propose, Judge, and I think this will in many ways sort of mitigate what the state is now arguing, and I would ask for it independently, frankly, is rather than refer to the defendant in this instruction, strike that and replace it again, we don't, if we specify that we're talking only about the defendant, then I can see where the state is saying that the court is commenting directly on the defendant's conduct in this case. But if we look at the question, I'm going to pull it back up again. Sorry, bear with me. Yeah, if we look at the question, it's not asking specifically about Mr. Jones. It's asking what does the law state. I think if we answer the question in the context of talking about an individual rather than Mr. Jones in particular, we're more directly answering the juror's question in the context in which it's asked, and we're mitigating the risk that the jury is going to make inferences with regard to Mr. Jones in particular in this case.
So, Judge, again, just referring to the question, that's all I'm referring to. What does the law state regarding pointing a gun at an unarmed person? It's not asking, when is it okay to defensively display a gun? It's asking, is it a crime actually to point a gun at somebody? And we're not giving them the full picture if we only tell them defensively display. And in fact, what we're doing here is we're directing them to a different standard completely than what they're asking about. What is it a crime to point a gun at somebody? And when would it be a crime? And if we're not telling them reasonable apprehension with a gun is also a crime, then we're not answering their question. And we're also changing the standard. When is it justified to use deadly physical force? Because now we're saying, in response to your question, jury, the defendant was justified even just pointing the gun at somebody if he was defensively displaying it, even if there's just physical force, which is different than what is prescribed in justification of self-defense statute. It's a big problem, Judge, and I didn't see it before, and I'm seeing it now, and now it's really going to confuse the issues here, especially when you look at their actual question, which is not talking about a defensive display, but rather an offensive display.
Well, I guess I don't parse it quite that narrow. They're asking, what does the law state regarding pointing a gun at someone? That could be with justification, could be no justification.
Right. And so my point is, Judge, isn't the law also that pointing a gun at somebody could be aggravated assault with reasonable apprehension? If we're not telling them that as well, then they're not getting the full answer. Because they're asking you, pointing a gun at an unarmed person can also be a crime? We're just saying, well, here's what it says when you defensively display it. We're not telling them at this point, is it also a crime to point a gun at somebody? That's the problem, and that's why it's actually included in that definition under 901.03, is because you got to get the full picture. If they're asking pointing a gun, they're not asking, is it okay for the defendant to have a gun and walk across the parking lot? They're asking pointing a gun at somebody, which is a completely, so we're not answering the question at this point.
So you want to put in reasonable apprehension of serious physical injury?
No, just physical injury by use of a gun. That assault definition should be included.
What is it? That's what I'm asking for. What is the actual offense listed?
A person commits aggravated assault if a person commits assault, and by, under 1203, by any of the following circumstances, if the person uses a deadly weapon or dangerous weapon.
Okay, hold it, Mr. Barker. I can't put all that in there. Okay? The paragraph we're talking about are those offenses listed under 706 and 90103.
Yes.
So what is the offense that you are referring to listed under 90103 or 706?
Aggravated assault by use of a weapon, intentionally placing another person in reasonable apprehension of imminent physical injury. That is included under 901.03. If we don't give them that, then we're not answering their question, because that is also a way to commit a crime. And that's one of the questions. Pointing a gun at an unarmed person, is it a crime?
Okay, just hold on. Hold on. You're making the same argument, and I'm trying to type.
Okay.
Is it reasonable apprehension of physical injury or serious physical injury?
Imminent physical injury.
So it reads aggravated assault by use of a weapon causing reasonable apprehension of imminent physical injury. Is that correct?
That's correct.
Yeah, Mr. Davidson, you were going to say something?
Judge, I think the court's already ruled on this, and I think it eviscerates the purpose of the instruction if we add in this qualifier that it doesn't apply if the defendant is intending to place someone in apprehension. It's usually, I don't see how I don't see how the issue of whether or not a person is trying to scare somebody with a gun could be an issue in the first place, or let me rephrase that. Obviously, we're dealing with a situation where a person is displaying a gun and possibly placing someone in apprehension if we're talking about this instruction in the first place. The question is, what does the law state regarding pointing a gun at an unarmed person? We're not required to give them a laundry list of all the crimes that could be committed by that. We're not required to give them all the civil actions that could arise from this. I think the simplest and most comprehensive way to answer this question is to say, look, this is what the law says in terms of when a person is justified in defensively displaying a gun. If a person's not legally justified, then there's criminal liability, but Mr. Jones isn't charged with any crimes arising from the display of a gun. So what those crimes would be is completely irrelevant. And the fact that we're giving them this instruction in the context of them to determine the lawfulness of whether the display or pointing of a gun was legal in the first place, I think it completely turns it on its head to give them the instruction and then say, oh, by the way, this doesn't apply if the defendant was pointing a gun at somebody. It totally negates and voids out everything that's in there. And if we give it to them in the way that the state is now proposing, you're essentially telling them, look, this is what the law says justifies the defensive use of a gun, but you're not going to be able to apply it in a case where a person defensively displays a gun. And I don't think that we should do anything more than give this instruction because it speaks in broad terms about conduct either being justified or unjustified. When we start getting down the slippery slope of talking about the different particular criminal offenses that could arise if it's not justified, we've gone beyond the scope of what we should be responding to and just muddying the waters and confusing the jury.
Well,
it is part of the instruction, is what counsel's not getting. This definition is actually in the instruction that we're offering to the jury. So we need to include that because it actually answers their question. And secondly, we can see the pattern here with the questions from the jury, which is, was Colin Brew, in fact, justified in lunging at the defendant at that moment? And if you leave out the fact that, yes, you can actually lunge at somebody if they're offensively using a gun, then we're not answering their question. And then if you look at the question the jury asked, we need to include this language, at the very least, that pointing a gun at somebody, or the language that the judge just typed down, is part of the reasons why defensive display is not justified. It's part of the instruction.
So two very quick things, Judge. One is, if we give the instruction the way the state is proposing, what we're essentially telling them is that you can find a defendant or an individual defensively displayed a firearm unless the defendant defensively displayed a firearm. And the second thing is, and I think if we take a closer look at this, this will point out the absurdity that would result if we were to give the instruction in the fashion that the state is proposing by qualifying this to situations only where there's not an alleged victim placed in apprehension. Look at that second bracketed paragraph, Judge. It talks about the defendant used a firearm during the commission of an offense. If you're talking about placing someone in apprehension as a result of brandishing or pointing the gun, that's not use, that's threat use, that's display. And if you look at Title 13 and all the offenses that are enumerated about use and possession and attempted use, the law in the state legislature is pretty clear that they can distinguish between use and threatened use. And when you're talking about disqualifiers based on the use of a weapon, you're talking about the weapon actually being used to hurt somebody, whether it's fired or used in some other manner. If you expand that word use to encompass situations where a gun is merely being brandished or pointed at somebody, you have just told the jury you can find that a defendant is justified in pointing a gun unless the defendant is pointing a gun.
So Judge, just as to that last point, the law actually says, first of all, that's included in the language in this instruction. 901.03 refers you to this exact argument the state's making. In fact, the language that the court just wrote down refers to that instruction, intentionally placing another person in reasonable apprehension of imminent physical injury if the person uses a deadly weapon. They're using that word. If you're pointing a gun, you're using that weapon to, in fact, place the person in reasonable apprehension. It has to be included. It's actually included in this language, suggested by the instruction itself. So to not include it would actually be a disservice to the jury, mislead them and confuse them even further.
Well, I'm going to give the defensive display. I'm going to modify the word the defendant to a person in this case, and I'm going to use the entire instruction, including the language that indicates how a person may not be justified in displaying a firearm. I think that is pointing a firearm at a person, and so I think that language needs to be included. It is part of the entire jury instruction. If I'm going to instruct the jury as to the law regarding pointing a gun at someone, and this is a defensive display, I mean, it's I'm either going to give this instruction or I'm going to let the jury wonder. And I'm going to give the jury instruction in its entirety, or the jury's going to be left to wonder. I mean, those are really the two options.
Judge, respectfully, Judge, I think if you add the apprehension aggravated assault, you've misstated the law and you confused the jury.
But how have I misstated the law if that in fact is under 90103? That is the bracketed language that I am to insert. I mean, I could literally put every crime under 90103 and 706 in there.
Right, because 90103 is referred to in the context of the defendant using a firearm during the commission of a crime. If we tell the jury that a person is not justified in defensively displaying a firearm, if they display that firearm with the intent of putting the other person in imminent fear of injury or death, then every time an officer draws down on a suspect that may or may not be armed, that officer is committing an aggravated assault, and they can't be justified by defensive display. If we read this instruction in this fashion and we adopt the state's broad use or broad definition of the term use, then anytime a person points a gun at somebody with the intent of placing them in apprehension, then regardless of how justified they are in placing them in apprehension, that person is not justified. If you read that into it and you put an apprehension aggravated assault into the justification instruction, you're basically saying it never applies. I can't imagine a situation where a person could defensively display a firearm to the point where it's an issue and there's not a concern about the alleged victim being placed in apprehension. The justification instruction by itself, just the totality of it, is from a 10,000-foot view, or looking at it in its totality. That's what it's talking about. Is when are you legally justified in placing a person in apprehension? You can't say this is when you're legally justified in placing a person in apprehension unless you're placing a person in apprehension. So the concept of the person being placed in apprehension is already presupposed into the justification instruction itself, and if you make that a disqualifier, then it eviscerates the whole thing.
In fact, it is actually in there. It is a disqualifier. Exactly. I think the judge's proposal is correct. Thank you.
Well, here's the situation. I mean, I understand it does seem somewhat of I mean, a tautological or circular analysis in this case, but in terms of does it accurately state the law in the context of the jury's question? That's what I'm trying to get at, and I'm trying to accurately and adequately instruct the jury regarding pointing a gun at an unarmed person. You know, I mean, I could just as easily see giving them the answer to 1, 2, and 4. You can rely on the instructions, your common sense, wisdom, and experience. I mean, I could certainly do that. And then there's no danger of having them decide against Mr. Jones on the basis of an uncharged crime. And they can simply rely on, you know, their experience, their understanding. But I think Mr. Davidson, if I give this instruction, excuse me, I have to give the full instruction. And if you want, I'll put all of the crimes in there. I mean, I'll put everything under 703 and 90103. But I don't necessarily know that, you know, I mean, that's what the instruction says. List the offenses under 706, excuse me, and 90103. That's, I mean, that's what it tells me to do.
It says if the defendant used the firearm during the commission of the offense. Look just at the first paragraph of this very instruction. It separates out the concepts of use and attempted use. If you look at other justifications in Chapter 4, it parses things out even further, talking about use, attempted use, and threatened use. If we read use just for the purposes of this one sentence so broadly that it doesn't require the actual use of a gun, but we're also talking about just the threatened use of it, when that term is elsewhere used in Chapter 4 but is noticeably absent from this particular instruction, then we've illustrated exactly why they narrowly use the term use. I mean, consider this for a moment, Judge. If we tell the jury that this justification instruction doesn't apply if the victim is placed in apprehension of injury, what we are telling them is the defendant is justified in defensively displaying a firearm if a reasonable person would have believed that physical force was immediately necessary to protect himself against the use or attempted use of unlawful physical force or deadly physical force, unless the defendant's defensive display of the gun placed the other person in apprehension of physical injury. That's just completely illogical, Judge, and I would respectfully disagree that we're giving the jury the full instruction. What we're doing is giving them an erroneous instruction.
All right, then I won't give the instruction. I'll just tell them to rely on their wisdom, common sense, and experience.
Either way is fine with the state judge, but what the defense counsel just said, the threat and use is still used. And they have the instruction on self-defense to decide if what his intent was is simply to actually harm people or to just be, act self-defense. So this goes beyond that. But if the court's going to give that, I agree with the court, you have to give that further instruction about what use is, including the threat and use to place someone in reasonable apprehension of physical injury.
Okay, on all four questions, the jury will be instructed. You are to rely on the instructions, your wisdom, common sense, and experience to answer this question.
I understand the court's ruling. I appreciate the opportunity to make a record, Judge.
Okay.
I would object and ask that it be given as requested.
All righty. All right, folks, let me just say, a couple of housekeeping things. The jury indicated that, assuming they didn't reach their verdicts before, they were going to quit at 3:30 today. They'll be back Tuesday at 9 a.m. So they opted not to come back in on Monday. So they'll reconvene on Tuesday at 9 a.m., okay? And then, Mr. Davidson, we were trying to find, and I don't know if Kerry got in touch with you. I know those memorandums were, basically done overnight, but we don't have the filed copy yet. Could you make sure that one was sent up? If not, would you please send up a copy, the one to be filed of your memorandum?
Will be right.
Okay. Thank you, folks.
Judge, sorry, one other thing. I know the defense counsel's in the Valley, and if there's a verdict at some point, how is the judge, are we just going to give them time to travel up? Is that the idea?
Well, what I had decided is that if it came in before noon, then I want defense counsel and defendant up here. If it comes in afternoon, then what I would do is I would simply ask, what I propose to do would be that all of the verdict forms be placed into an envelope, sealed with the jury foreperson's initials, and then it would be given to Cheryl, and she would keep it down in their safe, and then we would reconvene at 9 a.m. the next morning. Cheryl would bring up the envelope to the foreperson, and the foreperson could inspect it, make sure that nothing was tampered with, and then pull the verdict forms out, and we'd come back in and take the verdict forms that way.
Okay, all right, I appreciate that clarification.
All righty.
Your Honor, Mr. McCowan and I were prepared to come up this afternoon if necessary. I'm not sure, given the time that the jury indicated they're going to terminate their deliberations today, would make that practical or not, or necessary, I should say, but that's certainly something we're willing to do.
Okay. Well, I guess I kind of, I certainly understand the need for resolution and taking the jury's verdicts. They're going to be heading for lunch. Yesterday, they went out for a walk afterwards. I think they got back to deliberations about 1:30. And really, Mr. Davidson, I think, assuming they came back at 2, I mean, we could go ahead and take the verdict, probably be around 4:30 by the time we get everybody back together. But we certainly could take a verdict at that time. I tend to have my doubts that they're going to reach a verdict by 2 o'clock this afternoon. And so what I would probably again propose is that if they come back in the afternoon, that we just simply seal their verdicts and take the verdict on Tuesday morning at 9 a.m.
Okay, Judge. And just so I make sure I understood correctly, you indicated that they had deliberated until 3:30 today?
Correct.
Okay, thank you, Judge.
Okay. All right, thank you, folks. We stand at recess. Okay. I printed that out. Where is it?